Good afternoon, students. In today's topic, we will be discussing the second unit of your syllabus, which talks about the leading instruments or the role of international instruments in IPR. The material I have already mailed in your it has already been mailed with the references which you can take into account while you are going through this session. In this session, we will be going through the leading global initiative, which took the reason mainly for why this entire initiative was being taken place in IPR, followed by the different international instrument for patent or for the varieties of plant species, Budapest treaties. There are some kind of treaties which may not be mentioned in your syllabus, but I think during my lecture session in the class, I have mentioned them. However, if any kind of instruments which I haven't mentioned, you can mail me your query if so. So that was I hope through this session you will be understanding the minimum reasons why this particular international instruments were being taken initiatives. To begin with, the global initiative, the historical part is that it was during the during the disruption of World War II in the late 19th century, which caused a massive war, which actually virtually created a gulf in the free trade between the international community. That was because of this World War II, it was abandoned. And towards the end of this particular war, the US and the allied forces endeavored to create an initiative in the global perspective for establishing three international trades and payments. And for this, actually, this particular international instruments in IPR was the first stepping stone towards initiative for producing a kind of initiative in the IPR section. The intellectual property actually has a dual nature, that is both national and international dimensions. For example, if patent we are talking about, it is governed by national laws and rules of a given country, while in international conventions also, patent ensures minimum rights and provides certain measures of enforcement. Strong protection in IPR worldwide has become one of the virtual and vital important strata for future economical growth and development of all the countries, because they create a common rules and regulations on the international regime in IPR, thereby turning an essential to achieving the robust intellectual protection that spurs the global economical and expansion and the growth of the new technologies. To begin with, we'll start with the Paris Convention, which is included for patent. During the last century, before the existence of international convention in the field of industrial property, it was difficult to obtain a protection of industrial property rights in the various countries of the world because of the diversity in the law. The Paris Convention is one of the boon to the IPR, which was first signed in 1883. And since then, the convention has been revised several times. That is 1900, 1911, 1925, 1958, 1979 as well, and 1998. You need to understand that the industrial property does not include the intellectual property. The Paris Convention is one of such convention for promoting the trade among the member countries, and it has been facilitated to protect the industrial property simultaneously with the member countries without any loss. Further, there are certain kind of provisions which are talking about, especially Article 2 and 3 or Article 4, Article 6B's, 6 uniques, that is, it talks about the registration. 6C's, that is the protection. 6 steppies, that is unauthorized registration, and so on. Even though you can get the enlightened, in broad spectrum in the lecture notes in the study material that I have provided you all. Further, the Paris Convention, the framework, if we talk about, it is the other fundamental text of Paris Convention is a framework of privacy. Under the Paris Convention, an invention can be protected from the same point in time in a variety of countries. It is also a member of access into national patent system for foreign applicant. An inventor is able to claim the filing date of his first patent application in a convention country as an effective filing date for the further subsequent application. Therefore, it is therefore, if we can talk about if United Kingdom patent application has launched in 2002, on 1st January 2003, the same patent application is filed in Mexico, because it is a convention member country, and also that some such will be treated in other countries also. So basically, those are the countries which are coming to this particular convention or has signed the treaty gets the first priority than the other related filing patency, other related filing of the patent. So those are the member country get the priority basis filing than the other non-member countries. If you talk about the PCT application or Patent Cooperation Treaty is an agreement for filing the application having effect to 117 countries. And under this PCT, inventor can file a single international patent in one language with one of patent office in order to simultaneously get protection or seek protection from other 117 countries. The next is the new plant varieties, the UPOV International Convention, which talks about the establishing international convention for protecting the plant varieties. Yesterday, you people asked me the concept of the process. So I have also told you that plant varieties has one of the major important, or the UPOV, that is International Convention for the Protection of New Varieties of Plant, came into force in 10th August 1968, ratified in UK, Netherlands, and Germany, and further it has revised in 1972 and 78 to reflect technological development in plants breeding, acquiring with the applicant of this particular convention. Moving on is the Budapest Treaty. Again, it's a very important treaty because it has it has given recognition to use and to patent new microorganisms. The Budapest Treaty also recognizes the deposits of the microorganisms which are naturally occurring to be the subject of patent. However, naturally, what happens is that such as through gene insertion, mutation, however, natural occurring microbes that is manipulated or altered, such kind of through gene insertion or mutation can be also subject to patent. For example, if we talk about to describe a microorganism isolated from soil and improved by selection, example mutation, so that another person can be granted to isolate and improve exactly the same strain from soil in exactly the same way. Moving towards is the Madrid Agreement. Madrid Agreement registration established in 1891 under the Madrid Protocol in 1989, which was being signed in the by the International Bureau of WIPO, located in Geneva. In this particular, this particular trademark or Madrid, agreement offers a trademark owner the possibility to have his own trademark protected in the several country by one single filing. So with his own national regional trademark offices. Further, also it simplifies to a greater extent the mark, since it is possible to record the subsequent changes. So therefore, it is very important that the concept of this particular be designated subsequently. And also, you need to understand one thing, that for this particular Madrid Agreement is one of the trade is to be given the approval to those countries who have signed this treaty as well. Moving on is the NICE Agreement for International Convention Classification, which specifically gives recognition to the classification of goods and service for the purpose of registration of marks. It has been established by a Vienna Agreement, which is established the classification of figurative elements of mark, and it has further amended also in 1985. Moving on is the Trademark Law Treaty, which is that this particular treaty, which was being signed by almost 39 member countries, becoming the signatory states for numerous areas, that is both administrative and substantive, including harmonization or definition or registering the marks. Further, also, if you can kindly understand, this particular treaty provides the registration of sound mark, and also giving such other, eliminating the doing business requirement for parties to own the trademark, and also to protect well-known marks and its and of its higher renown or for its goodwill. The next for the copyright, that is the Berne Convention, which was initially adopted in 1886, but again it has been severally changed, and later on it has been adopted in 1971, 1979. It has been adopted in Paris itself. The Berne Convention actually states that all work should be protected at least 50 years. That is for the photography, it's 25, cinematography for 50. But there are certain kind of countries who have given a longevity period. For example, in UK, the extended date of standard period is 70 years from the death of the author. Further, if we talk about India, it has extended plus 10. Yesterday, which I was talking to you all on the live video that I was talking to you, that it is 60 years. It has been varied into 50 plus 10. It is not 60. Even though in UK it has given the extension of 70 period, but in India it has been given 50 plus 10 years extension being given. That is total of 60 years of extension. Next is the UCC. UCC is an alternative towards the the alternative to Berne Convention. UCC was developed by the United Nations Education, Scientific and Cultural Organization, and it is wished to participate in the form of multilateral copyright protection. This particular treaty developed in the Soviet Union and granting the protecting the and granting by the Berne Convention, and also the United States and Latin America were already the members of Pan American Copyright Protection. Therefore, which was the weaker than the Berne Convention. Therefore, the Berne Convention states also become party to the UCC so that their copyright would exist even to the non-Berne Convention countries as well. The next is GI. GI is known as the geographical indication. The GI in Madrid was being inserted in Madrid system. It was the first attempt was founded in Paris Convention, followed by the the elaborate provision. It is in Lisbon Agreement on Protection of Appellants of Origin and its registration. Few countries joined the Lisbon Agreement, but however, this particular the Lisbon Agreement, which was initially, but then later on about 170 countries indications were registered under Lisbon Treaty till now as of 1997. So basically GI I have told also, where it is giving a different approach and standard to the government to use to register the GI, which gives a mark to a particular product based on its topographical and geographical enunciation of any kind of product. The next is the agreement of trade related aspect, that is the TRIPS, which was an offshoot of Marrakesh Agreement, establishing the WTO or World Trade Organization. And this particular WTO and the TRIPS was signed in Marrakesh Agreement, that is in Morocco. This particular agreement talks about the standard for intellectual protection. It came in 1995 and it is still binding on with the WTO, that is World Trade Organization. Trade-related aspects is mainly giving implementation to enact the Patent Act patency or it's registered in the 150 countries, and this standards includes the patent be given for a minimum of 20 years, and that patent can be given to the products for both the pharmaceutical test data and also giving protection from any kind of unfair commercial use. There are three standardized features of this agreement. First is standard, enforcement, and dispute settlement. Already discussed in class, the standard means that the TRIPS agreement's laws and properties which is governing that structure must be well established enough. Enforcement, it should enforce in giving remedial for the intellectual property or any kind of unfair use. Dispute settlement, in case the agreement makes in dispute between WTO members about the respect of the trades to such WTO disputes will be resolved. The next were brought about the GATT Uruguay round in the late 1880. which talked about giving protection to at least 200 companies, especially few pharmaceutical ones. The next is also that TRIPS gives enhancement to biopiracy, farmers' right, and also health and pharmaceutical rights are there. But along with it, it also has given extended its genre in biopiracy. Now, what is a biopiracy? Biopiracy is a right of community of natural resources not guaranteed. Indeed, TRIPS does not recognize a community ownership of the resources it has tended over 1,000 years. Farmers' right, that is the right given to the farmers, not provided for TRIPS agreement, but TRIPS does not permit farmers to save seeds grown on their own land for future purpose. The next is WIPO, the World Intellectual Property Organization, is one of the 17 specialized agencies. At present, it has 184 countries, and it actually it's the predecessor of BURPI, that is the Bureau Internax Réunis la Protection de la Propriété Intellectuelle, French acronym for United International Bureau for the Protection of Intellectual Property, and established in 1883 for protecting the literary and artistic work, and the Paris Convention for the protection of industrial property. It was established, came into force in 1970, and it is one of the specialized agency of UN. It further also, it gives under this. Unlike other branches, WIPO has significant financial resources, and under the intellectual property and registration system, it administered the PCT, Madrid, Hague, and Industrial Convention as well. So that was all for entire this session. I hope you have understood what are the importance of international instruments in IPR. But however, if you haven't understood, or you want certain clarity, you are in a very good situation to kindly mail me your concern, and I will be in a good I will be in a very I will be comfortable in clarifying your problems, if any. That was all for today. Thank you so much.